Do you need this?
My background is English literature and humanities, and I became very interested in the relationship between the humanities and death and issues of grief and mourning. Became so interested that I certified in thanatology and have been teaching death and dying classes as well as medical humanities and research writing and humanities classes here. And as part of the study of the death system, I've become interested in the dilemmas, the paradoxes, and some of the problems surrounding the death penalty, convictions and executions. I'm particularly concerned about the ratio between people who commit murder and those who are actually sentenced to death, who receive the death penalty, what was your number that you had? 0.5%?
Yeah.
0.5% of the people, 600,000 murders since 1976, and only 0.5% of those have received the death penalty. So this does seem not to be fulfilling the goal of justice, and I'm concerned with some of those issues.
Okay, my name's Harmony Jove. I'm an undergraduate here. I'll be graduating next semester. I'm a senior right now. Right now I'm working on a research project with the A team. There's 10 of us, and we're studying Utah residents' attitudes about the death penalty. I'm not sure what else to say, but yeah, with our project, we're particularly concerned with what Utah people think about the death penalty, and especially how much they know and what they're basing their opinions on. And we'll be showing that research to the legislature when it's completed. So,
Do you want to talk about how you're going to do it?
Oh yeah.
And where you are with it?
Yeah. Right now, we're just about to send out our pilot study. That's just going to be a study of students here at the school to test the validity of our instrument. Our instrument is a 4-page long survey, and after the pilot study, we'll be sending it out through mail to 6,000 people in 6 purposefully selected cities, and we'll choose random addresses within those cities. And yeah, hopefully we'll get back some good results.
You think you'll go to graduate school?
Oh yeah, I hope so. If so, anyone will take me.
Come to Albany.
Yeah.
Well, that's enough. That is enough. Can I go to Albany?
Yes. You can all come to Albany.
Albany is maybe the #1 criminal knowledge program in the country, one of the top in the world. So if she goes to Albany, we'll all be pleased.
Yeah, and best friends forever. Okay, I'm Sandy McGonigal-Smith, Associate Professor here in Behavioural Sciences. My PhD was based on a study of 7 of the men on death row here in Utah, and my study was about, it wasn't about what brought them to death row, it wasn't about their crimes or their backgrounds, it was simply a question of how do you get through each day? How do you wake up in a supermax prison, which for those of you who don't know, supermax prison usually is 23-hour-a-day lockdown, 1 hour out a day in isolation, and no contact visits with anybody, very limited access to education or any other kind of anything else that would help you hang on to your sanity, basically. So I wanted to know how they would get through each day in those conditions, knowing there was very little light at the end of the tunnel for them, knowing that they weren't working towards release. So that was what my PhD was on, and I've published, co-authored several articles since then with Robert Johnson from the American University on different aspects of that. I've also done a comparison of people under the sentence of death with people who will never get out of prison alive, people who are serving the sentence of life without parole, or people who know for various reasons, for a number of reasons, that they are not going to get out of prison alive. So I was looking at the difference, what are the differences between those two sentences? And like Alan said, I've been involved in other research, but that really doesn't have much relevance on what we're talking about today. So that's me.
Tell him to slow down. If he wants to.
Is he close?
Sorry, go ahead.
Okay. Okay, I'm going to talk, but just, you're all on notice that your opportunity comes after Alan talks, because we're all going to count on you for your thoughts and ideas and questions. So start making note of what you'd like to talk about. I'm going to try to bridge a couple of themes that we heard earlier this morning and sort of look for the reality that law and the death penalty in particular are this seamless web. Everything seems to be connected with everything. I'm from New York, and we, for years, did not have capital punishment because we had governors who were opposed to the death penalty and vetoed capital punishment legislation. And then in 1995, a governor took office who supported the death penalty, and a death penalty statute was enacted in New York that remained in effect until 2004, when our High Court declared that it was unconstitutional on procedural grounds. So we had a recent decade experience with the death penalty. It was a much ballyhooed initiative that was divisive and dominated some of the campaign talks. What happened during that 10-year period was seven people were sentenced to death. 0 were executed. More than $200 million was spent in the process. And New York is sometimes associated with the theme, be careful what you ask for, because that decade was plagued with procedural and jurisprudential issues, and when all was said and done, with much agony, the death penalty was put behind us. And now we're in a new era, and one of the themes I'm sensing today is the importance of state-specific examination of capital punishment, its history, its implementation. And I'm so glad that there's research being undertaken here about Utah's history and present experience and attitudes about the death penalty, because it's going to be so important. And we learn dramatically that the experience of one state with the death penalty can be so different from the experience of another state. And what are those experiences? Well, we will know as your research gets farther underway. Another theme is that without the death penalty, New York now is one of several states where life without parole is the maximum punishment. And the opportunity to evaluate the significance of being in a jurisdiction without the death penalty is now available to us in New York. And one of the issues is going to be, well, what has changed for the better or worse now that capital punishment is not available? And an issue of concern to many is, what about this population that Sandy knows more about than probably anybody in the country, of prisoners sentenced to life without parole? Some people think they have nothing to lose while serving their sentences, and this population may create untold problems within prison. A lot of experts say that simply is not the case, that prisoners doing long time, hard time make remarkable adjustments to prison environment and have a lot of incentives not to be disruptive. And in fact, those who commit murder, perhaps surprisingly, tend not to be the kinds of offenders who present the most significant disciplinary problems. But again, the need and desirability of research on that issue and many others. Alan spoke eloquently earlier this morning about international trends in capital punishment law and the implications of that for the United States jurisprudence, and an area that I know he, again, knows as much about or more than just about anybody that he did not get a chance to talk at length about is the extent to which international opinion has affected American jurisprudence on capital punishment. And Alan may or may not want to follow up on this, but in a formal sense, there is a raging discussion, to put it in nice terms, among justices on the Supreme Court about the legitimacy of referring to international law and practice as a mechanism to help interpret the meaning of the United States Constitution's 8th Amendment. And if you think about what the Eighth Amendment prohibits, it's cruel and unusual punishments. What's it mean for a punishment to be cruel? Yeah, there must be some way to break down that concept. So the court refers to many indicators, and some of the justices believe that it is not irrelevant to consult what the international community is doing to see if American jurisprudence is administering a punishment that can be considered cruel. Now, I gather that on more informal terms, because who are these members of the Supreme Court? They put on their robes like you and I do, I assume. They're human beings. They talk to other people. Their life experiences are shaped by communications with others. That Justice Kennedy, who tends to be the swing vote in so many 5-4 decisions, and Justice Ginsburg and Justice Breyer, for example, frequently take summers or extended vacations and lecture in Europe, spend time affiliating with professional organizations in Europe, and as Alan was suggesting during his talk, their ears are being bent frequently by their European colleagues, and you have to think that when it comes time to write their opinions, these opportunities to learn more from others in other countries may make a difference. Of course, that opinion is not unanimous. Justice Scalia is a diehard in terms of this is a United States Constitution, and these international norms don't make much of a difference to him. And finally, Nancy's area of interest, death and dying from a kind of therapeutic, sociological perspective, I don't know how best to characterize it, is another interest of mine. Some colleagues and I in Albany have begun working with other researchers in other parts of New York, in Ohio, and Indiana, and we're doing focus group interviews with murder victim survivors, that is, family members of individuals who have been murdered. And there's an extensive literature that I don't know very well. I'm sure Nancy does, about homicide. Imagine the unimaginable. I hope nobody has had to go beyond imagining, although this touches a lot of people. But if a family member of yours were killed, death is difficult under any circumstances to deal with when it involves a family member. But a homicide is a special kind of death. It's unexpected. The grieving process is different. There's a trauma in addition to the natural process of lamenting the loss of a loved one. And we are very interested in being able to be as responsive as possible to the needs of murder victim survivors. We're exploring in part the significance of the death penalty to murder victims' family members, but it's so much more complicated than that. And the penalty that an offender may receive tends to be a rather modest issue in terms of what we are learning murder victim survivors think is most important to them. So keep thinking, because your turn's coming next after Alan.
I think I will pick up on what Jim was saying from a slightly different angle about the use of international law and whether or not it should affect U.S. law, and particularly U.S. constitutional law. And if you go around the world, you become very, very quickly aware that the U.S. is an outlier here. So far as I know, we're the only nation that doesn't pay attention to what other courts do and say. And we're almost, there's a bit of, it's not ridicule because courts are too polite, but they will sometimes comment on it. But if you read, if you go, or if you sit in the Canadian Supreme Court and just listen to the arguments, people arguing, people have no hesitation to cite a South African case, or more likely a British case, less likely French and civil law, but they will cite cases from all over the world and do it with regularity, and not an eyebrow is lifted. Everyone accepts that. But it's not just the citations, because when you start reading the jurisprudence of the Canadian Supreme Court or the South African Supreme Court or the United Kingdom or Australia, New Zealand, or any of these countries, they're not only citing cases from other jurisdictions around the world, but they're finding reasons to either follow or distinguish those cases. They're taking them seriously, in other words. They take, and they will look at the similarities and differences between their legal schemes to decide whether a case is appropriate analogy to look at or not. And there's not a discussion. If you look at the Canadian Charter of Rights, which is in many ways similar to the U.S. Bill of Rights, although it has some protections built in that the U.S. doesn't, and has some escape loopholes that the U.S. doesn't too. So it's not identical. But if you study the Charter of Rights, you realize that from the very beginning, the Canadian courts were interpreting their Charter of Rights in light of rights in the United Kingdom and the U.S. And if you go into Canada and you look at their cases, they're citing U.S. cases and even following U.S. cases. A good example is with search and seizures of juveniles in courts. If you look at the Canadian Supreme Court case and the U.S. TLJ case, the reasoning, the logic, everything of the case follows pretty nicely together, and there's no problem. So we are an outlier. We're one of the few nations that says, oh, I don't want to hear anything that some other nation does, it's irrelevant. Well, it's irrelevant to the present Supreme Court, at least to some members of it, but the international opinion is beginning to filter down, as Jim hinted, at the state level. A number of courts have said that they are paying attention to international opinion. In Oklahoma, in the Torres case, and Nevada, in the case there recently. So international opinion is starting to filter down. The resistance is at the U.S. Supreme Court, and primarily with Scalia. And that causes interesting problems, too, because Scalia decided to do a residency at the Irish Center for Human Rights, which was fine, except all the graduate students wanted to sort of shun him and treat him rudely. And the director, Bill Shabas, had to basically sit on his students to make them be polite. Now, that's a little tiny story, and it doesn't affect things directly, but it does sort of show the extent to which much of the rest of the world sees us as a human rights outlier and is almost disdainful in some ways, although it's a very polite disdain. It comes through in jurisprudential and diplomatic language, but you learn to read through that and you realize that there's just real surprise at the way the U.S. treats international opinions and the way it fails to sort of take other people's. It's almost as if we're just too good, for them. And so that's the comment that I would have on our not looking at other cases, is that we really are alone there. So with that, let's open it up to questions. Yes?
I'm curious for you and the
Set?
how prisoners cope with being secluded for that long and having no hope.
Hope.
Just the prisoners that are sentenced to life that have no hope of getting out, that are secluded and can't see people for such a long time. I'm curious.
Are you talking about life without parole or death row?
I haven't studied the difference.
Okay, because there is a kind of a difference. Life without parole prisoners, there's a wonderful work written by Robert Johnson called Mature Coping, in which he suggests that after a period of time, lifers, people facing long periods in prison or the rest of their life, will cope. They'll find a niche for themselves in prison, and they'll make the best of a bad job, and they will cope. But talking to death row prisoners, I said, how do you cope?
I have a quick question. Death row is like they are going to die?
They're going to be executed. Yeah, or there's a chance they will be. They don't know when, they don't even know if. But the average time on death row at the moment is about 14 years between being sentenced and being executed. So there's that long period. So one of my questions was, how do you cope? And I came across this very interesting concept called tripping. When I asked the first guy, how do you cope? He said, I trip. And I thought, trip? How do you get drugs? You're in Supermax. How do you get drugs? And he said, no, I didn't mean that. He said, what I do is I take my mind out of the prison. And I said, tell me. And he said, I pace up and down the cell for hours at a time. He said, and eventually my mind isn't here. My body is. My body is where it's supposed to be at the right time, at the right place. Nothing I can do about that. But they can't get here. I take my mind out. I go camping. I decide where I'm going to go before I go, who I'm going to take with me, what beer I'm going to drink, what friends I'm going to have with me. And I thought, my goodness, how interesting. So then I went back and did a second round of interviews with the death row guys and asked them, did they trip? They all did. They all did. But it was interesting because it was a technique that they taught each other, and it took years to perfect. And some of them once told me I could be out for hours. He said, and a sudden loud noise will bring me back. And I get so pissed off, was his words, when I have to come back and I realize where I really am. So does that kind of answer your question? Yes?
Nancy, I have a question for you. In the penalty, it seems like there's a lot of discretion. Judges have discretion, prosecutors have discretion about whether they're going to go for a death penalty conviction. What kind of effect does that have on that person? What effect, what sociological factors factor in to how that person then has to deal with going for a death penalty conviction or sentencing someone to death?
Are you asking about how it affects the prisoner, the person who's being sentenced, or
The other person.
maybe the prosecution?
Yes.
So, well, there are, as you say, a lot of factors, and I am not a prosecutor. I'm not an expert on legal issues. Maybe Alan or Jim could answer that question a little better. But I know that there are some, they try to consider extenuating circumstances. I know that if the family of the victim makes a specific request that, yes, we do want you to go for the death penalty, that is considered. It is also considered if the family of the victim requests that the death penalty is not sought. So those kinds of things do have a place in the prosecution, but different states have different regulations, and even different counties within different states have different ways that can be applied to the death penalty.
Ted Blochtel has just joined us. I don't know, I guess we'll just continue with the panel with Ted on it. You can ask Ted. I guess the first thing is give a 2-minute introduction. 2-minute introductions to who you are and what your interests are, and then we'll keep this going for a little while, and then we'll put you on whenever you feel like you want to go.
Well, the guy's been traveling about 36 hours, what should have been a 6-hour trip. I haven't shaved or changed or anything, but here I am. So thank you for having invited me up to the front to join you. I have some sense of what one might be saying about death penalties, and having shared many of those views, but I don't know. I'm a president and founder of a small new graduate school called the International Institute for Restorative Practices, and as you might imagine, that relates to restorative justice, and I guess that's okay. Thank you.
We'll just keep having the questions going for a little while. Yes.
If the average weight in the U.S. on death row is 14.5 years, how does that compare internationally? In countries that do have the death penalty?
Who? Harmony can answer that? Okay. Good. Let Harmony answer that.
It varies really widely. There are some countries where, where was it? Ecuador or something, where they were they were executed 4 hours after they were sentenced. So I think you can't really compare it. It's just a huge, differing scale. And I think it varies a lot from case to case. But that was maybe not as much.
I think it's in China or Japan that if you get past 9 o'clock on Friday morning, you know you're safe for another week. And that's about as much as you do now.
China is an interesting comparison because until fairly recently, you would be convicted in China, and it's my understanding from Mark Warren, who's the expert on this and who does all, by the way, if you go to Amnesty's site or the Death Penalty Information Center's site, it's Mark Warren who's done the research on most of these foreign executions and foreign international law and executions. But they would take you out and shoot you, with a bullet in the back of the head within hours. It was convicted, carried out to a field, shot. And they had, no one knows the precise numbers because they wouldn't provide statistics, but estimates ranged of as many as 10,000 executions a year. It was huge, huge numbers. International criticism of the Chinese system and that sort of thing has really brought to bear on the Chinese. And while they still have the death penalty, as you saw the numbers that were put up on the board, and I don't remember them all, but it was in the hundreds. So we've gone from maybe 10,000 to many, many hundreds, but still a huge drop. One of the reasons that drop has occurred is that now everybody who's convicted of a capital crime in China is entitled to an appeal to the Chinese version of their Supreme Court. I'm not sure what they call that court, but to their Chinese Supreme Court. So that's one difference. And so they have also narrowed to some slight degree the numbers of crimes for which you can receive the death penalty. Unfortunately, they still have capital crimes for corruption and certain kinds of things. They also have an interesting procedure which I've never heard of anywhere else in the world, and that is that they'll have a conditional death sentence, which is to say that you go onto death row and you stay there for 2 years, and if they change their mind, then it gets converted to, I guess, so many years in prison. I think Bill Shabas, who was here a few years back, is the expert on that. He was telling us all about the changes in Chinese jurisprudence, which I thought was quite fascinating. But Harmony's answer is that it varies so wildly around the world is right, but just as the U.S. is subject to international pressures, other countries are as well. And I know this, that I think, was it Gambia, or it's an African nation where they're suddenly just taking them out and shooting them within hours, and they've got several dozens who are on death row, and Amnesty is putting a tremendous amount of pressure on. And you might wonder whether that pressure will do any good or not, but the point is that that kind of pressure from groups like Human Rights Watch and Amnesty and diplomats and the European Union, there's all kinds of pressure being put on. So these speeds that nations go to kill people, to execute people, it varies a lot, but it's also much more sensitive to international pressure than it ever was before.
I think Utah is pretty much in keeping with that 14 and a half years, maybe even longer here in Utah. Ronnie Lee Gardner, I think, had been 22 years on death row, I think. I could be wrong. So Utah's up there.
Yeah, it's an interesting question. Just to reiterate what's already been said, the Chinese experience is fascinating. They now have, as Alan said, the sentence of death with a 2-year suspension, meaning in law, if you behave yourself, if you don't commit a major infraction during the first 2 years under which you're sentenced of death, the sentence will be commuted to life imprisonment. And to me, that's a marvelous compromise between what I believe is a principal function of capital punishment, which is the symbolic significance of imposing a sentence of death. You get that when the judge says you shall die, but then you don't have to carry it out, except in those cases where for some reason it's an extraordinary sentence. In Japan, as Sandy said, the prevailing governmental view is that one under sentence of death is such an outlaw, it is outside of the law, that neither the offender nor the family nor anyone is entitled to notice of when the execution will occur. So they live in perpetual state of waking up in the morning not knowing if this is the morning when the execution will be carried out. The United States, my guess, is probably alone in this 14.5-year separation between typical sentence and typical execution. The reason for that lengthy delay is, as you know, we have a federalistic court system, and a death case will produce a voluminous record, and it may take months to years before the appeal is prepared and argued and decided, multiple years before the state Supreme Court will pass judgment on the legitimacy of a death sentence. And that's just the beginning. And then there's an opportunity to go up to the U.S. Supreme Court for discretionary review, or to go collaterally and raise what's called issues on post-conviction review. And these are issues that could not have been raised on appeal because they're not reflected in the record. For example, the typical claims are, my lawyer was drunk and asleep and otherwise incompetent. And that won't be reflected in the record. Seriously, that happens, but more typically, there were witnesses out there that were available and were never interviewed, and I need a hearing in order to develop the kind of a job my lawyer did. And another post-conviction claim is there was prosecutorial misconduct. The DA had exculpatory evidence that was never produced, and I'm just now finding out about it, and I need a hearing. So now there's going to be a delay, and we need an evidentiary hearing to flesh out these issues, and then there's an appeal. And we're still in the state court system, and this will usually go to the Intermediate Court of Appeals. Does Utah have a Utah Court of Appeals and then a Supreme Court, or is it just a... okay, so some smaller states, smaller population. This will go up to the state Supreme Court eventually. Then you can ask the U.S. Supreme Court once again to review your case, and that takes time, and we're still getting started because we haven't even put a toe in the water of federal court review. There's federal habeas corpus, which is available to any state prisoner who wants to raise a federal constitutional issue, has a statutory right to do so in federal court. And now a federal district court judge is going to have to set a time for consideration of a habeas petition, and that, another big record, because now we have the appellate issues, the collateral issues, and now more time passes. And then there's an appeal to in Utah, it would be the 10th Circuit Court of Appeals. And then you can ask the whole 10th Circuit en banc, which is all, I don't know how many, 10, 12 judges to consider the 3-judge panel decision. And then you go up to the U.S. Supreme Court. And lo and behold, as through 1995, during this protracted process, 2 out of 3 death sentences are tossed out because serious error was committed. So the extended time does uncover, typically not innocence, because all of this appellate stuff is not, it's geared toward issues of law. But in the meantime, there's an opportunity to do serious investigation of innocence. And among the 141 exonerated people, it usually, they're spending 9.5, 10 years on death row before they're able to demonstrate innocence. So the U.S. is probably alone. Is it worth the well, to find that error, to find the innocent people? Can it be sped up? Well, there are some measures designed to. There's statutory requirements, but whether you want to sacrifice speed for thoroughness is, again, another one of those issues that needs to be thoroughly thought about at a minimum.
Yes.
Just briefly, could you flesh out any arguments in favor of the death penalty and whether you think it's valid?
We could talk about the arguments that have been made without my necessarily agreeing with them. The one argument that is left standing after you knock down all the utilitarian arguments is the National Academy of Sciences says that there's no good evidence one way or the other to determine whether or not the death penalty deters. It's pretty clear it costs a lot of money, racist in administration. So the utilitarian arguments empirically seem to cut all in one direction. The argument that's left standing, and the one that is made by, in various forms by Robert Blecker, who was here, I think, last year, and made by various others, Vandenhaeg and so forth, is retributive justice. The notion coming mostly from Kant that justice comes in respecting one's autonomy, respecting autonomy. And the idea is that if somebody does something really good and works hard, they should be rewarded. And if somebody does something very bad, then they've essentially violated the social contract, and therefore, to respect their autonomy, one should punish them, and punish them in a way that is, in some sense, equal to the crime. And so that's the argument that is made. Jim made a couple of variations on that this morning when he talked. There are problems with that, and they're very difficult philosophical problems. Okay, you want to?
No, I had a small point.
Okay, well, I'll pass it to you in just a second. If you're going to respect all people equally, which is the basic premise of a Kantian universe, that one should treat other people sort of as the golden rule, to act upon that rule that you could universalize, that you could apply to all people. And if you do that, then the notion of equality, of all people sort of counting for one, is embedded within this notion of justice. And if you take that seriously, then the argument on the other side is that you then must take seriously that of the innocent person. And in a system where we know that it's absolutely foreseeable that a certain number of innocent people will in fact be executed and another certain number will be wrongfully convicted, a Kantian is not, in my view, taking life seriously, taking autonomy seriously, taking equality seriously. Now, the Kantians have an answer for that. They say, well, it's the doctrine of double effect, which was basically a war doctrine, a doctrine justifying war, which has been transposed over into the death penalty situation. And they say, well, we didn't intend innocent people to die, so therefore we're okay. Well, it seems to me, and the answer that is suggested by Rich Lempert at the University of Michigan, and one that I think is very much, is that very much underappreciates the power and force of statistics and statistical reasoning. In fact, Rich writes, he says that statistical reasoning in its own way is quite precise. And if you know it's absolutely foreseeable that you're going to kill innocent people, then you can imagine two societies. One society that chooses, let's say, 5 scapegoats and kills them simply for utilitarian reasons, to stop riots or whatnot. That was often the argument that was made in the lynchings in the South. You may recall, for some of these who have historical interests. And another society where we know we're going to have a death penalty and we know people are fallible. Well, if the empirical evidence begins to suggest that there will be a 5% error rate, we just don't know who, then I would argue that it's just as morally irresponsible to use a retributive doctrine and to try to duck it under the doctrine of double effect when you know you're killing innocent people and you know that you're going to do that and that there's no way out of doing that. Now, that argument has been developed much further by Laurie Witt, who's a philosopher who's spent a lot of time developing Rich Lempert's argument further, and I'm not the expert that she is on this, but I can turn you on to some readings. In fact, Jim here, I think, was editing the Criminal Law Bulletin when we published that article and when we made the same argument. Mm-hmm. Is that right? Mm-hmm. Yeah, my memory is not so good, but I think Jim published one of Laurie's and my articles making this very point about the doctrine of double effect. And so I'm not going to defend retributivism, and I think it's flawed. But I will tell you that that's the argument that you will hear anyone make. And in fact, when I was practicing law and defending cases, all of the assistant AGs in the Virginia death squad, as we called them, the people who did nothing but death penalty work, that was the argument. They would concede right off the bat. I said, well, you know it doesn't deter. Yep, I know that. And you know that this is inefficient. Yep, I know that. But by gummy, they deserve it. And that was the argument that's made. And so there are variations on it. Jim made a couple this morning, and I think Ted wanted to mention it. But that's the basic argument, retributive justice. That's the one that's left standing at the end of the day, and the one that is intellectually the most respectable at this point.
Yeah, sorry, I didn't mean to interrupt. I just got enthusiastic about it. Just, one of I mean, on a popular level, and other people often make the argument from a biblical sort of point of view, and it was interesting to me because I had always misunderstood the phrase "an eye for an eye, a tooth for a tooth," and so there's some justification for a life. And I'm not a biblical scholar, but I have come to understand that it actually was a limitation, and it was meant to be not more than an eye for an eye. And so it's not what a lot of people think is a good biblical justification for taking lives.
Anyone else want to touch that argument?
Well, this is sort of something out of my own thinking. I am not quoting scholars or any sociological studies, but I am wondering if the reason that we have, or at least one of the reasons that we have supported the death penalty for so long, is it's a symbolic reason, that it goes back to the idea of purging, of cleansing ourselves, our culture, that we feel that by taking someone's life for a horrible crime that they have committed, it somehow makes recompense for the whole culture. And I think back to ancient times with the practice of sacrifice in ancient cultures. This was their prominent belief, that in order for them to be protected from evil, they must sacrifice, live sacrifice. And I think this may be part of a subconscious reason for our acceptance of the death penalty, is that symbolically we feel that we have participated in some kind of, I feel just the opposite. I feel like there's blood on my hands whenever there is an execution, that I have, through legitimizing or allowing the state to take the authority to take someone else's life, that is a reflection on me, and it does not purify, but it vilifies me. But I wonder if this symbolic idea of ritual sacrifice subconsciously promotes our thinking that the sacrifice of someone who has committed evil may be a protection for our culture.
Let me just, one further string in the bow for those who support the death penalty. Let me refer to an argument that Ernest von den Haag advanced, and it relates to a more practical utilitarian justification, which is deterrence. There is debate in the scholarly community about whether capital punishment does deter murder. The preponderance of evidence suggests no, but some suggest yes. And some of the studies, for example, are to the effect that every execution might deter 7 future murders. One study put it as high as 32 future murders. Now, what von den Haag argued was that if there's a dispute, and you really don't know for sure whether executions do or do not deter, that morally your choice is between taking the life of a guilty murderer with the prospect that we may not be accomplishing much of good, versus not executing a guilty murderer and potentially sacrificing down the road 7 to 32 people who might be alive. And for him, that was a no-brainer. If we don't know and we're risking this, well, clearly this person who's committed murder deserves it vis-a-vis the other people who might be saved. So the next time you get into a heated discussion about this, you can roll that one around too as another possible reason to support capital punishment.
Yes.
You had mentioned cost. What is the difference between having someone on death row going through all the legalities versus having someone maybe like in prison without possibilities of parole?
Well, Jim did a wonderful job of talking about this. So you've addressed it to me, but Jim addressed it this morning. There's one point he didn't make. If you're going to do a death penalty case, you're most likely going to have a trial. They don't plead as often, so there's a higher rate of trials. That's the first thing. So that's a cost. Then the trials are more expensive for a variety of reasons. There are more judges take more time, there are more lawyers, there's more security, there are more expert witnesses, there are more pretrial motions. So the average trial, depending on the state, might cost in some states as little as $500,000, in others average trial may be $1 million or more, just to try the case. Well, the problem is that you're only going to get a death verdict in some proportion. Was it about 50-50, Jim? Mm-hmm. Jim was saying this morning it's about 50%. Well, the other people who don't get the death verdict are probably going to get life in prison without parole. So you've got a cost that most people don't think about, which is that if you get the death penalty, you've got all these appeals. If you don't get the death penalty, you've had a more expensive trial to begin with, and all of that cost has to count against the ledger, okay? Then, as Jim was pointing out, you have various appeals, you can have more security. I've been on death rows, and if you go into a death row, they are extremely secure, lots of extra guards, specialized guards. But then, I know in Virginia, and I don't know how it's done in every state, but in Virginia we had a death house. So that's a cost. That's a capital cost to start with. They had to build a separate building. But they didn't want to build it on the same grounds as the death row because of all the problems that an execution causes within a prison. So they built a separate death house and a separate prison. So between the appeals where you've got to bring the prisoner out and you've got police and so forth and all the appeals, you've also got costs there on the actual execution. It's not just a few cents worth of chemicals. You've got a death house, you've got to watch this prisoner, you have 2 guards 24 hours a day making notes over everything they do the last 2 weeks of their lives. If you really understand how the capital system works, you would realize that no matter how much you speeded it up and no matter how much you streamline the appeals, you will never ever get it to where it costs less than it costs for life imprisonment. So those people who said, well, let's just make the system more efficient, yes, maybe you can shave $1 million off. It's possible. I'm not going to deny that you couldn't. But then the other side of that is, if we're already executing innocent people, and we've already got 141 wrongful convictions, some of which came within hours of execution, do you really want to streamline a system to have more wrongful convictions? And if you're a retributivist, if you're honest in your retributivism, and I don't care whether it's social contractarian retributivism or where you come from with your retributivism, if you're going to respect life equally, does it really make sense to streamline a system to save money, a little bit of money, and execute more innocent people and still pay more than you would have paid for life imprisonment? That's the question you have to ask yourself, and that's the way you have to put the question when it comes to cost.
Can I just to keep the book straight money-wise, there's also something we tend to forget is that over 10% of the people on death row opt out of the process. They go for what's called a voluntary execution. That costs money.
Oh, yeah.
There's always psychological evaluations. Co-counsel have to visit them again. So just as a matter of housekeeping, keeping the book straight, I think we have to factor that one in as well.
Yes.
My question is, over that 10-year period in New York where it was legal but nothing ever came of it, all the money that was spent on it, what were the main lessons that were taken away from that? Like what came out of that?
You learn from your mistakes, I guess. There has not been any energy in New York to resuscitate the death penalty statute. The Court of Appeals in our state identified a single flaw that was correctable. It was a procedural issue, and the legislature considered whether to come back and fix it, and they decided not to. There was considerable testimony from many constituencies, including law enforcement, prosecutors, the defense bar, victims, citizens generally. And when all was said and done, it seemed like our system would be better off without all of the issues associated with capital punishment than with it. Now, as I mentioned this morning, some interesting, clearing of clouds from the horizon, as it were, emerged in that there has been a very active group in New York that has capitalized on the removal of the death penalty, which they believe has been an obstacle to bringing people together to talk about issues of common interest that everybody shares, no matter if you're 100% in one camp or 100% in the others. We can all agree that children need certain assistance in the maturation process, that guns in the hands of wrong people on the street are not a good thing, that gang violence plagues communities, and the elimination of the death penalty has facilitated serious policy discussions among law enforcement, victims groups, communities that may never have been talking to one another before. I'm going to let Ted have a crack here. You probably know David Kaczynski well. That's who I'm referring to, who's been the leader of the post-abolition. I mean, if you're against the death penalty, which David and his group were, you have to be for something as well. And what they were for was, well, let's get serious about what we can do that will help us all to avoid having to think about punishment issues.
Well, yeah, I'm against the death penalty simply because I think we make too many mistakes, and I think that the cost of keeping people incarcerated for life is well worth the cost. So, I mean, that's oversimplistic, but what do you do then with everything else that comes out of a serious offense? So that's what I'm going to talk about. Actually, not just serious offenses, but aside from the fact that there's a murder committed, and the assumption is that we can reduce crime by doing justice, at least in some people's minds, that will in fact deter. Well, we can argue that, and there's some serious question as to whether the criminal justice system reduces crime at all, or by creating the kind of prisons we have actually exacerbates it, because most people do get out. So, it gets into larger questions. But then, for me, the question is, and that I'm particularly interested in, is how do you reduce the impact of crime? So I will tell some stories and things, starting with a murder. But
Yes.
Okay, in reference to like deferring or discouraging murder by using the death penalty, I think it was Freud that said like we cannot consciously imagine our own death unless we can't fear our own death. Psychologically, for people on death row, was that true or false prior to their committing murder, or is it true or false after their sentences for death?
Sounds like
Do they
sign
fear
day,
their own
maybe.
death? Can you use someone's own death to scare them? Does that make sense?
I think if I understand you rightly, no, like I said, 10% of the people on death row say, bring it on. Let me get on to the next experience, whether they're religious or whatever. I'm done with this, let me move on. I don't think they particularly fear death. There is this natural instinct to cling on to life. But, and then again, like what we've spoken about this morning, I don't think very many of the people on death row wake up one morning and decide to go out and commit somebody, to go out and kill somebody and think, but then am I going to be frightened about what's going to happen to me? I don't know, maybe Nancy can answer that better than me.
I really haven't had the experience with the prisoners that you've had, so that, I think your answer is probably, yeah.
Did that answer you? Yeah. Anybody else? Somebody at the back in the middle?
So if you, I mean, capital punishment, I'm assuming was sort of meant as a punishment for those particularly heinous murders. If you do away with capital punishment and you just have life without parole or life imprisonment, I guess I'm wondering where this may sound strange, but the opportunity to experience that, I don't know a better word than punishment, but to experience that punishment and that opportunity to, I mean, lesser punishments are something that you do to pay back and to be completed and make things right and move on with your life for both parties. So when it comes to things like murder, what would be in place or what is in place for the prisoners to have that opportunity?
I think that's a Ted. Is that a Ted one?
Well, I'm sorry, I don't have anything to add.
Well, okay.
Maybe Harmony then.
Well, let me just take a quick crack at part of it, and then I'll pass it to Harmony. What you're arguing essentially is a retributive thing, that punishment, as Kant would say, is good in and of itself, is a good in and of itself, that punishment is important to respect people. And there are a couple of answers to that. One I just gave about the fact that retributive justice must also take innocence into account and respect that. But the other thing is that ask yourself this. When we talk about punishment, when was the last time you heard of burning an arsonist's house down as punishment? Or raping a rapist? Or raping the rapist's child? When was punishment ever seen as this kind of absolute equivalence? We always, in our legal system, come up with, if you're speeding, your punishment is a fine, right? The legal system has always come up with ways to grade crimes and to grade punishments. If we're going to do without the death penalty, that doesn't mean that we're necessarily going to do without punishment.
Do you want to go ahead?
Yeah, I had a sort of thing.
Okay.
I'm a little punchy, frankly. I'm really tired.
Anybody who's been in the Denver airport for 24 hours deserves
Just about punishment, a few words about that. I think about punishment not just in the criminal justice system, but I work a lot in schools, and I work with delinquent and at-risk kids who aren't necessarily deeply embedded in the criminal justice system. And I guess the thing that always strikes me about some of our assumptions about punishment is we often describe it as holding people accountable. And yet, if you stop and actually look at the process of punishment, it's actually very passive. That is, you get punished. And you get to be angry at the people who are punishing you. And you get to think you're the victim. And you don't actually reflect on how you've impacted other people. And you don't actually, you're not asked in any of the punishment systems we have, whether it be school or courts or whatever, they don't actually ask you to figure out how to make things right, or, you just get punishment. So where's the accountability in that? So I would contrast what I'll be talking about, a restorative system where whether or not there's a sanction, and we suggest that given the realities of the world, I'll just use schools for an example. When you throw a kid out of school, and the school board has mandated for certain infractions that you have to throw them, you suspend for certain, whatever the sanction is, but you could still get people together in a circle and talk about how people have been affected, and I'll be more explicit about the process, and giving people a chance to really gain some shared understanding of how everybody's been impacted, because they're going to go back into the same classroom with all the undertones and tensions, and the punishment will not have changed any of that. So if you have to do sanctions, and we may, I don't think restorative justice replaces people going to prison necessarily, either politically or for other reasons. You may still have some sanctions. Some people are very dangerous. They might not, we may have a good reason for for keeping them in a confined situation, because they'll hurt people again. But at the same time, getting back to, so what do you do with the rest of it? What do you do with all the ripple effect of harm on all the people? And interestingly, some of the victims are actually the family and friends of the offenders. They've been harmed too, and there's nothing in our criminal justice system currently, I shouldn't say nothing, very little or nothing. There are victim impact statements, which, you know, is a gesture in that direction, but that's not face-to-face, and it's not a dialogue. And so those, you know, that's what interests me about punishment. You may have to do it, but you can still do something more.
Yeah, I'm going to hand this to Sandy and Harmony, but I'm going to make an executive decision that we'll take one more question, and then Ted was supposed to have been speaking this hour, and he's very kindly let us sort of go on with the panel. I think we should call the panel after another question or two, and then one question, and then take a very short break. And Shannon, are you going to introduce Ted then? You have to. It'll just be a few minutes. No, it's not. If you're prepared, or you or Michael. But anyway, let me pass this on, and then we'll take one more question.
You could
And then we'll clean up that. That's okay, John. I understand. Extenuating circumstances.
Okay, so in regards to this question, I think it's important to note that our alternative to the death penalty right now is life in prison without parole. And in many European countries, that's considered cruel and unusual punishment. So when you think about punishment, I think that can suffice as a form of punishment for really severe crimes. And also what Ted was saying about reparation to the victims. There are some very good programs in place in Utah, especially for reparation to victims of normal crimes, but there aren't very many programs in place for murder victims and things like that, because when someone's been murdered, who do you do the reparation to, because the victim is dead? But their families still remain, and they're victims of the crime as well. So I think an interesting alternative would be reparation to victims' families and things like that. But
I've just been thinking about an interview that I had with a comparatively young man who was doing life without parole. He was from Korea, I think, or I think it was Korea. He knew nobody in Utah. He'd come here to start a new life for himself, had got married and had a baby, and killed his wife. His wife's family took the child away from him. I came to interview him, a very passive individual, very meek, very well behaved. In fact, he was in the minimum security section of the prison. He was such a low security threat. And I asked him the questions that I've asked many prisoners. What's the most painful aspect of imprisonment? None. Well, what do you least look forward to? Well, everything's okay. What do you think about the food? And nobody in their right mind could say the food was good. He said, it's okay. And what he was saying to me was that this is okay with me. What I did was terrible. And in a sense, I don't think it was punishing him. I think it was helping him cleanse and heal himself. So I really don't think that we're that sophisticated about our knowledge of punishment. I think it requires a lot deeper thought than we realize. So I hope that helps.
One more question. Yes.
What percent of inmates would you suggest are found to be clinically depressed once they've been handed a sentence, a death sentence, for example? And if so, how much of a positive factor would that be in further criminal activity within the system?
None of the people I spoke to were clinically depressed. None of them. They did make comments such as, well, you can't keep somebody in a box like this for 14 years and let them go out and expect them to function as a normal individual. That's never going to happen. But most of them seem to adopt what Robert Johnson called this mature coping, making the most of a bad situation, carving a life out for yourself. They were not, jumping up and down with joy, but no signs of clinical depression, although other people, Craig Haney and people like that, have written extensively about not even so much death row, but the pains of solitary confinement and supermax prisons.
Okay, that was it. It's,
Thank you very much. We